The U.S. Supreme Court heard oral arguments on Thursday in a historic case that could determine whether former President Donald Trump is eligible to run for president again in 2024. The case stems from a decision by the Colorado Supreme Court, which ruled in December that Trump was barred from the state's ballot under Section 3 of the 14th Amendment, a provision that disqualifies anyone who has engaged in insurrection or rebellion against the U.S. government. Colorado's ruling was based on Trump's role in inciting the violent mob that stormed the U.S. Capitol on January 6, 2021, in an attempt to overturn the results of the 2020 presidential election. Trump's lawyers challenged the ruling, arguing that only Congress has the power to enforce Section 3, and that the states have no authority to remove a candidate from the ballot based on their own interpretation of insurrection. They also claimed that the Colorado ruling violated Trump's constitutional rights and disenfranchised millions of voters who support him. The Supreme Court agreed to expedite the case, as it could have a significant impact on the 2024 election cycle, which is already underway with several states holding their primaries in March. The justices appeared divided along ideological lines, with the conservative majority expressing skepticism about Colorado's argument and the liberal minority questioning Trump's defense. Chief Justice John Roberts asked whether a state could ban a candidate who openly declared himself an insurrectionist, while Justice Sonia Sotomayor wondered whether a state could ignore a congressional determination that a candidate had engaged in insurrection. Justice Brett Kavanaugh suggested that the court should avoid deciding the case on the merits, and instead dismiss it on procedural grounds, such as lack of standing or mootness. The court is expected to issue its ruling by June, before the end of its current term. The case has drawn national attention, as Trump remains the frontrunner for the Republican nomination, despite being impeached twice and banned from several social media platforms. Several other states, such as Maine, Minnesota, and Oregon, have also attempted to exclude Trump from their ballots, citing Section 3, but their efforts have been blocked or dismissed by lower courts. Section 3 was enacted after the Civil War, to prevent former Confederate officials from holding federal office, but it has rarely been invoked or enforced since then. Some legal experts have argued that Section 3 is outdated and ambiguous, and that it should be repealed or amended by Congress. Others have maintained that Section 3 is a vital safeguard for democracy, and that it should be applied to Trump and anyone else who threatens the constitutional order.